Yes, my respected and learned brothers and sisters. This is Advocate P. Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Hope all of you are nice, happy. Today I selected a very good topic on law point. That is from Civil Procedure Code 1908. The topic is Order 7, Rule 11 of CPC. That is for rejection of plaint. First of all, I'll read out the provisions of Rule 7, Order 7, Rule 11, CPC. Rejection of plaint. The plaint shall be rejected in the following cases. A. Where it does not disclose a cause of action. B. Where the relief claim is undervalued and the plaintiff on being required by the court to correct the valuation within the time limit to be fixed by the court fails to do so. C. Where the relief claim is property valued, but the plaint is written upon paper insufficiently stamped, and the plaintiff on being required by the court to supply the requisite stamp paper within a time to be fixed by the court fails to do so. D. Where the suit appears from the statement in the plaint to be barred by any law, then also suit can be rejected. E. Where it is not filed in duplicate. F. Where the plaintiff fails to comply with the provisions of Rule 9, provided that the time fixed by the court for the correction of the valuation or supplying of the requisite stamp paper shall not be extended unless the court, for reasons to be recorded, is satisfied that the plaintiff was prevented by any cause of an accidental nature from correcting the valuation or supplying the requisite stamp paper, as the case may be, within the time fixed by the court, and that refused to extend such time would cause grave injustice to the plaintiff. Now, this is the law position. Plain reading of Order 7, Rule 11 of the Code of Civil Procedure makes it clear that the relevant facts which need to be looked into for deciding an application thereunder are the averments in the claim. Only averments and documents filed along with the application can be considered and with the suit. At the time, defense is not to be considered. Now, I'll refer year 2024, Patna 164. Para number 23, page number 169. Moreover, reading of the Rule 11 of Order 7 of the Code of Civil Procedure will show that neither suppression of fact, this is to be noted in the mind, neither suppression of fact nor misrepresentation nor even fraud has been made a ground for rejection of plaint. Even the rule does not include abuse of process of court as a ground for rejection of plaint. Clause A and D deals with absence of disclosure of a cause of action and the suit appearing from the statement in the plaint to be barred by any law. Whether the plaint discloses cause of action for the suit or not has to be decided on only based on the averments made in the plane and the documents produced along with the plane. These two things, averments in the plane and the document produced along with the plane. These two things are to be considered while deciding the application under Order 7, Rule 11. The cause of action alleged may not be true or may be deliberate falsehood. The court dealing with a petition under Order 7, Rule 11 of the Code of Civil Procedure cannot go into question whether cause of action alleged in the plate is true or false and taken a decision based on the defense plea taken by the defendant or based on the documents produced by the defendant. At that time, defense is not to be considered. But one thing is very good now. Please pay your attention. On the other hand, there may be a case in which the pleadings in the plaint itself having the effect of destruction of the plea regarding the cause of action and making such plea regarding the cause of action illusory. Drafting itself can be destructive. If it is so, then plaint can be rejected. Only in such view of the case, the court has to decide whether cause of action alleged in the plaint is real or that the plaint has been drafted in an interior manner to conflict an illusory cause of action as a real cause of action. The court can reject the plaint on the ground that the plaint does not disclose a cause of action. The scope of Rule 11 of Order 7 of the Code of Civil Procedure has been explained in various decisions and the legal principles deducible. The materials to be considered for rejecting the plaint has been dealt with in the case of, this is a very important citation I am reading out, Diamond versus Arvind by Kalyan Bhanushali. In bracket 2020 FCC online SC 563, equivalent AIR 2020 SC 3310. The apex court has settled the principle in para number 12.6 and 12.7, which reads as under. Now 12.6 para. At this stage, the plea taken by the defendant in the written statement, an application for rejection of the plaint on the merits would be irrelevant and cannot be adverted to or taken into consideration. Now 12.7 para. The test for exercising the power under Order 7 Rule 11 is that if the averments made in the plaint are taken in entirety, relied upon, would the same result in a decree being passed. Means the test is as to whether if the averments made in the plaint are taken to be correct in their entirety, a decree would be passed. This is the test. If decree can be passed, then it can be rejected. Now in Hardesh Ores Private Limited versus Hede and Company, in bracket 2007, bracket complete 5 SCC 614, the court further held that it is not permissible to cull out a sentence or a passage and to read it in isolation. It is the substance and not merely the form which has to be looked into. The plaint has to be construed as it stands, without adding or subtracting of words. If the allegations in the plaint prima facie show a cause of action, the court cannot embark upon an inquiry whether the allegations are true in fact or not. If, on a meaningful reading of the plaint, it is found that the suit is manifestly vexatious and without any merit and does not disclose a right to sue, the court would be justified in exercising the power under Order 7, Rule 11 of CPC. Here the phrase right to sue. I'll explain now. The provision of Order 7, Rule 11 is mandatory in nature. It states that the plaint shall be rejected if any of the grounds specified in clause A to E are made out. If the court finds that the plaint does not disclose a cause of action or that the suit is barred by any law, the court has no option but to reject the plaint. Now, in this video, we'll discuss about a cause of action, a period of limitation, the right to sue, first accused, what is the meaning of it, the intention of the parties, power of court under Section 151 of CPC, when suit can be dismissed under Order 10, Rule 1 of CPC. Now, the question arises when CPC Order 10, Rule 1 is applicable in this case. Citation 2002 AISC 569 Delhi High Court. Sri Madanlal Vaid versus Sri Nanda Kumar Walia and another. I'll read out. Now the question arises as to what appropriate order should be passed when the plaintiff has suppressed true facts from the court to make out a flimsy cause of action. If there is suppression of material, then what power court has got? Does it mean the court is powerless to deal with the litigants who filed frivolous and vexatious suit concerning material facts from the court? In this situation, what is to be done? Now, Order 7, Rule 11 says no. Then what is the alternative? The answer of this question is provided by the decision of the Supreme Court in the case of T. Ravindaram versus T.V. Satyapal, reported in AIR 1977 SC 2421. Honorable Supreme Court observed that if clever drafting has created illusion of a cause of action, the evidence should be nipped in the bud by examining the parties searchingly under Order 10 of CPC. It was held that such bogus litigation should be struck down at the earliest. Material facts were suppression from the court only to make out a sham, flimsy cause of action and should liable to be dismissed under Order 10, Rule 1, CPC. This is very important provision. Now, let us understand the meaning of cause of action. What do we mean by cause of action? Cause of action means a cause which gives rise to an action in law. Cause of action to be called out on a conjoint reading of all paragraphs of plaint. Cause of action means every fact which would be necessary for the plaintiff to prove if traversed in order to support his right to judgment. It consists of a bundle of material facts which are necessary for the plaintiff to prove in order to entitle him to the reliefs claimed in the suit. It must include, this is very important, it must include some act done by the defendant. Since the absence of an act, no cause of action can possibly accrue. It is not limited to the actual infringement of the right sued on, but include all the material facts in which it is founded. Now, this has been discussed in number of citations. 1997 ASC 1995, ER 1998 SC 3085, bracket 2005 10 SC 51, ER 2012 SC 3912. There are category of judgments on this. Now, let us see the provision of Limitation Act 1963, particularly Section 58 and 59. The period of limitation prescribed under Article 58 and 59 of the 1963 Act is 3 years, which commences from the date when the right to sue first accrues. The right to sue first accrues. What is the meaning of it? How to be considered? In Khatri Hotels Private Limited versus Union of India, in bracket 2011 9 SCC 126, equivalent EIR 2011 SC 3.90. Supreme Court held that the word sue and accrue, these two words, would mean that if a suit is based on multiple cause of action, the period of limitation will begin to run from the date when the right to sue first accrued. That is, if there are successive violations of the right, it would not give rise to a fresh cause of action, and the suit will be liable to be dismissed if it is beyond the period of limitation counted from the date when the right to sue first accrued. Now let us understand what the right to sue, what is the meaning of it. A three-judge bench of the Supreme Court in state of Punjab versus Gurdev Singh in bracket 1991 bracket complete 4 SCC 1 equivalent EIR 1992 SC 111 held that the court must examine the plaint and determine when the right to sue first accrued to the plaintiff and whether on the assumed facts the plaintiff is within time. The word right to sue means the right to seek relief by means of legal proceedings. The right to sue accrues only when the cause of action arises. The suit must be instituted when the right asserted in the suit is infringed or when there is clear and unequivocal threat to infringe such right by the defendant against whom the suit is instituted. Expiry of period of limitation does not debar a court from exercising powers under Section 151 of CPC to set aside rejection of plaint under Order 7, Rule 11. This is discretionary power to Honorable Court. An order of rejecting plaint cannot be set aside under Order 9, Rule 9 or Section 151 of CPC. Clause D of Order 7, Rule 11 speaks of suit as appears from the statement in the plaint to be barred by any law. Order 10, Rule 11. In bracket 2005, bracket complete, 7 Supreme Court cases 510. Popat and Kotecha Property versus State Bank of India, Staff Association responded. Para 10, page number 515. Disputed questions cannot be decided at the time of considering an application filed under Order 7, Rule 11 CPC. Clause D of Rule 11 of Order 7 applies in those cases only, this is important, but the statement made by the plaintiff in the plaint, without any doubt or dispute, shows that the suit is barred by any law in force. If it is, then dismiss. The trial court must remember that if on a meaningful and not on formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, it should exercise the power under Order 7, Rule 11 of the Code, taking care to see that the ground mentioned therein is fulfilled. If clever drafting has created the illusion of cause of action, It has to be nipped in the bud at the first hearing by examining the party searchingly under Order 10 of CPC. Now, what is how intention to be gathered? The intention of the party concern is to be gathered primarily from the tenor and terms of his pleadings, taken as a whole. At the same time, it should be borne in mind that no pedantic approach should be adopted to defeat justice on hair splitting technicalities. Now, let us see some legal points. Expiry of period of limitation does not debar a court from exercising power under Section 151 of CPC to set aside rejection of plaint. Number two, if plaint does not make out a case of fraud, deception, or even confusion, it is liable to be rejected. Number three, order as to rejection of plaint can be passed only by referring averments in the plaint and not by referring material placed by defendant in reply to plaint. Extraneous matters cannot be considered to reject the plaint. Taking into account materials beyond plaint to declare case of plaintiff as frivolous and vexatious is beyond scope of Order 7, Rule 11. Documents which form basis of the suit should be available with the plaint and can be looked into. When a plaint is based on a document, the court can consider it to see if a cause of action is disclosed, but the validity of the document cannot be considered at that stage. So long as a claim discloses some cause of action or raises some questions fit to be decided by a judge, mere fact that case is weak and not likely to succeed is no ground for striking it out. Allegations in plaint constitute prima facie case and cause of action. Plaintiff also paid sufficient court fee. Admittedly, no written statement was filed by the attendants, then application for rejection of plaint by defendant not maintainable. Specific mention of fact in plaint. The defendant refused to execute register sale deed. Manner of refusal are matters of evidence. Evidence need not be pleaded. Order rejecting plaint on ground that there was no cause of action, it is not proper and it cannot be rejected. But the plaint does not disclose a cause of action. This is important. Court should not reject the plaint then, but should allow an amendment to the plaint. If on meaningful, not formal reading of plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, the trial court should exercise its power under Order 7, Rule 11, Civil PC, taking care to see that the ground mentioned therein is fulfilled. The trial court should insist imperatively on examining the party at the first hearing so that bogus litigation can be shot down at the earliest stage. Should totally false, vexatious, and meritless and abortive litigation should not be permitted to occupy time of court. Judicial time should not be wasted. By principles of res judicata, the plaintiff is liable to be rejected under Order 7, Rule 11. The court had no jurisdiction to entertain the plaint in absence of a statutory notice being given. even if amendments made in the plane are not in conformity with the provisions contained in Order 1 or Order 2 regarding misjoinder of parties or cause of action, such defense cannot put forward as to attract the provisions of Order 7, Rule 11D. Plaintiff cannot be rejected. Since an order passed in rejecting the claim under Order 7, Rule 11 for lack of cause of action amounts to a decree, therefore such an order is appealable. But where an application under Order 7, Rule 11 is rejected, that is not appealable. Review. An order rejecting the plaint can be reviewed if the conditions of Order 47, Rule 1 are satisfied. Even where the plaint dismissed under Order 7, Rule 11 could not be restored under Order 47, Rule 11, then the court could do so under its inherent power. This is the end of this topic. Hope all of you have enjoyed it. If you are our permanent client, regular client, then please subscribe it, share it, and like it. If you are new and if you are not subscribed it, please subscribe it. Even if you're not new but you're not subscribed yet, then please subscribe it and share it and like it. And by that way, please encourage me to produce videos on important and useful topics. Thank you very much. Thank you, thank you, thank you. Shri Krishna Saranam Mama. Hari Om Tassat.